Well, in a recent landmark ruling, the Supreme Court of Nigeria has affirmed that the Freedom of Information Act must be applied across all levels of government, including the state and the local governments. But then there are still concerns around sustainability and implementation. Well, joining us online to make meaning of this development, talking about the significance of Supreme Court judgment and Freedom of Information Act is a legal practitioner, Barrister Muhammad Usman. Good morning, Barrister, and thank you for joining us on the show this morning.
Good morning, and thank you for having me.
All right. Just briefly, what exactly are the stipulations of the Freedom of Information Act?
The Freedom of Information Act, which came into law in Nigeria sometimes in 2011, is a 14-year-old enactment which has gave Nigerians the right and opportunity to request and also obtain information from the government. When I say government, I mean both administrative and all other arms of government, and also all other agencies and parastatals of government. And this law has made it clear that such requests are to be obliged within specific time and specific period, and failure to oblige on such requests made by citizens of Nigeria is meted out with consequences on the agency and individuals that are capable or that are saddled with the responsibility of issuing out those informations or public records as requested by individuals, to the extent that it also provides a law mechanism whereby failure to do that by such individuals who are capable or who are saddled with such responsibility can be enforceable before a court of law. And then when the court reviews such act of that agency which refuses or which neglected or which failed to give such information as requested by individuals, it can be meted out by sanction. So this is the scope of the law. Although I must add that it is not all manners of informations or of records which will be requested must be obliged by such a public agency or private agency or institution which received the request. There are categories of exemptions which exist within the confines of the said enactment of the National Assembly.
You did mention that the act in itself is already 14 years. So what brought about the recent ruling by the Supreme Court on the same act? If it's been in existence for 14 years, how come it has been, for lack of a better word, comatose?
Yes, you see, in our climb, there are instances whereby a law will be in existence, but then the manner of its applicability is something entirely different. There is an issue which arose in Edo State, whereby a community of civil society organizations requested an information concerning HIV/AIDS development project in Edo State from an agency that is saddled with such responsibility, an agency of the Edo State government. So when such request was put to that agency, it refuses to oblige the people that the people that made the request. So that was what prompted the coalition of that civil society organization to file the case of Austin Osaku against Edo State agency of government. So at the first step, the Federal High Court in Edo State, that's Federal High Court Benin Division, upheld the sacrosanct rights of the people that made the request that the agency was wrong, to have refused to oblige them and to issue them with the records and information they requested concerning the HIV/AIDS grant issues surrounding its donors and all records pertaining the workings of that agency as far as data is concerned. So when the Federal High Court upheld that request, the agency felt they are not satisfied with that judgment of the Federal High Court. So they appealed to the Court of Appeal, Benin Division. And the Court of Appeal, in its own wisdom, decided to hold that the Benin Division of the Federal High Court was wrong, that the applicability of that law, according to the Court of Appeal, and as argued by the appellant before that court, was that it is a law or it is an enactment that only binds federal parastatals or the federal government and its agencies. It is not applicable to state government and its agencies, meaning it is only one tier of government, that is the federal level, that are bound by the Freedom of Information Act 2011. So the appellant, that is Austin Osaku, representing the coalition of civil society organizations, were dissatisfied with the judgment of the Court of Appeal as well. So they appealed finally to the Supreme Court, where on Friday, that is I think in the last 21 to 22 hours, the Supreme Court on Friday upturned or overruled the findings and judgment of the Court of Appeal Benin Division, and it led down the precedent that we now have, which stated categorically that the application or the applicability of the Freedom of Information Act 2011 is not restricted to federal government and its agencies alone, but rather to all arms of government and to all tiers of government, including the state level and also the local government level, and also private institutions, or rather any institution that's held in its account or in its custody informations that can be regarded as public in nature. So this is in a nutshell what brought about the landmark judgment of Friday, the 11th day of April, 2025.
All right, what in your your experience would you say this act, the implications of this act would be on governance, seeing that it has trickled down from the national to the grassroots? What are some of the implications on accountability and transparency? And how can civil societies and even individuals assess information using this tool, talking about the Freedom of Information Act?
Yes, in my opinion, this is a watershed judgment, as commented by a lot of people and a lot of representatives of civil society organizations and the general public, because the public applauded the recent decision of the Supreme Court, not only because it goes only to the advantage of the public, but it cut across the advantage of a lot of institutions, particularly the coalition of civil society organizations, whose main aim is to ensure that public governance is brought to limelight and also to the benefit of the general public. That is one. And also another segment of institutions who will use the recent judgment in facilitating their activities in Nigeria is the journalists, or the press rather, and also the third tier of individuals or people who benefit from such judgment directly is the general public. So it will go a long way in giving these categories of people or institutions or individuals the opportunity to checkmate, or the opportunity to probe, or the opportunity to investigate the activities surrounding governance in Nigeria at all levels, at all tiers of government, because it goes a long way in trying to say that, okay, yes, since public governance is all about representing the people, and the leaders or the government is a representative of the people, then the people must have an opportunity to inquire, to request, and to ask about records and informations that are used in governing them. So that is the whole gamut of the decision of the court on that day. So that is why, according to your commentator, the judgment of Friday is not a win on a legal battle, but rather it is a win for democracy in Nigeria. And I also agree with him. It's a win for democracy and a win for the rule of law in Nigeria.
Are there some legal obligations, rather, by the state and the local governments following this, ruling?
Yes, exactly. The legal implication is that by law, a judgment handed down by the wisest men, that is the justices of the Supreme Court, as did yesterday, or rather as did on Friday, in the judgment that we are discussing about, has now laid down a precedent that, contrary to the arguments of state governments and local governments, that they are not bound by the provision of the Freedom of Information Act, because according to them, it is an enactment of the legislature at the National Assembly, has now been watered down by this judgment. So this judgment has now come to be the position of the law from Friday in Nigeria, that the applicability of the Freedom of Information Act cuts across the federal government, the state government, and also the local government. And therefore, anybody or any institution that is found to have contravened the provisions of that law will now be liable to the strictest punishments that is provided under the law. So since they are now coming under the law by virtue of the pronouncement of the Supreme Court, then they must be ready to uphold completely the entire provisions of the Freedom of Information Act 2011, or rather, they'll be meted out by the punishment prescribed under the law for defaulting to oblige the request of Nigerians, or the request of civil society organizations, or the request of any individual citizen who made such request to them for information or public records that is not made available to him within the prescribed time as enshrined by the Freedom of Information Act itself.
In terms of public awareness, how exactly would you advise, steps to be taken to educate the public on how best that the act is actually, available, what their rights are under this act, and how to utilize this tool?
Yes, I think there are windows of procedures whereby public can be enlightened on this recent judgment, because there has been a backlash in upholding the Freedom of Information Act, particularly across the state and local government levels. So now with this judgment, I think the main or one of the most important beneficiaries of the act in terms of applicability, and those who have been at the front row in trying to enforce it, is the press. So fortunately for us, the press are very close to the people, and Nigerians are very, very close to media. So the media, I think, for me, is the best avenue whereby Nigerians can be enlightened, Nigerians can be brought to limelight that this is now the provision of the law as far as the Freedom of Information Act is concerned, so that any individual or any citizen of Nigeria will feel free as of right to approach any entity or any institution or any public organization for the purpose of requesting for records or for informations which he wants to utilize for his own purposes. And in fact, the Act, even by Section 2, I think, provides that a party who is requesting for information must not even state to that organization that this is the purpose or this is the interest that he has for the information. All he needs to do is to put across a request in writing. And if he cannot put across a writing, the law allows him to go into any office which he wants to request from and make the request orally. So it is impending on the officer in that institution to take the record or to take the request in writing, and also to oblige such request within 7 days. And maybe, if need be, extend the period for the request maybe to another 7 days, but also a formal notice must be given to the person making the request that there is need for an extension. And if there is also a reason not to oblige the request, or maybe the category of the request falls under the exempted information that would not be released to public as provided by the law, then also a notice must be given to the person making the request that for so reason as provided by the Freedom of Information Act, we cannot be able to oblige you with the information you requested for. So if the person feels still aggrieved, then he can approach the court of law to review the finding or to review the position of that institution as to why his request was not granted. So I think the media is first and foremost the most easiest and the most seamless avenue whereby Nigerians can be fully enlightened as to the impacts and as to the importance and significance of the Freedom of Information Act, and also the bar that has been there as far as its applicability and enforcement is concerned has been lifted as of Friday by the Supreme Court of Nigeria.
Barrister, do you envisage or anticipate any form of pushback or any form of challenge in implementing this particular act in Nigeria, given the fact that, well, for example, the local government autonomy experienced a lot of pushback? Do you think the same might apply with this particular act?
Well, I think so to a limited extent, but to a larger extent, I don't think there should be a bar because the court has already made it clear. But you are right, enforcement is sometimes something entirely different. But with this judgment, I think it is very clear and apt that the court has taken a very bold position in that regard. So it will no longer be an excuse for the state government to refuse it. Because if I may say, the main reason that the state government has been creating friction as far as the applicability of this law is concerned is that there is no corresponding provisions in the state's laws that provided for or rather that correspond with the Freedom of Information Act. I mean to say that the state laws does not provide for such provisions. So that is why there are these frictions. So now, since they are straightforward, applicable to the state by extension, by the provisions, or rather by the recent judgment of the Supreme Court, I think there shouldn't be any bar anymore, because the act is very clear that this is the way to enforce it, or rather this is the way to make requests in the first place for recording information. Where there is default, this is the way to go about it, and then I think the provisions are now clear. So I don't envisage straight away a situation that will be justifiable for any institution or for any organization or for any individual to deny any citizen of Nigeria henceforth any record or any information requested from an organization or from an institution of public nature.
Contain any mechanism for compliance, ensuring that all governments at all levels comply with this act. Then again, does the act also contain a legal recourse should there be, failure to comply, with the act?
Yes, this act is, I must say, one of the most interesting enactment that has ever been made by the legislative arm of government in Nigeria, because it's all encompassing. I don't think it has left any stone unturned as far as the issue of information to be made available to Nigerians is concerned. The act provided, as I said earlier, that it is within 7 days that a request must, as a matter of necessity, be obliged to Nigerians when such request is put forward to an institution of government. However, like I stated earlier again, where there is need for extension, maybe because of the bulkiness of the documents or of the record that is being requested, there may be an extension of 7 days. So after that, there will not be any justifiable reason anymore for that institution not to oblige to such request. Where that is found not to have been done, then the act provides that the person or the individual or the organization that made such request can approach a court of law, and it has provided clearly the court that can entertain such cases. So being in the federal enactment, the right avenue to land in is the Federal High Court. So it is the Federal High Court that, at the first stage, is saddled with the responsibility of upholding the provisions of the Freedom of Information Act where they are found to be violated by any organization or by any public agency, either of the federal, state, or local government. And it also provides further that the officer who is in charge of giving out such information which he withheld for reason maybe best known to him or for no reason at all, is liable upon conviction and found guilty by the Federal High Court to a fine of 500,000 naira. And in order also to entrench or to ensure accountability, the Act further provides that other measures can be taken or any other order that the Federal High Court deems fit to give. It can give where it found somebody or it found an organization wanting or in violation of the Prohibition of Information Act. And it also add that where a person or an agency is found to have concocted or to have created or to have made false record for the purpose of obliging a request of an individual, that person will also be liable to a term of imprisonment of 1 year, whoever he is, and within the federal government level or the state government level or even the local government. So this is the mechanism for the enforcement of the act, and I think it's very, very clear, and that is the same mechanism that Austin Osaku, representing the coalition of civil society organizations, followed, and he arrived finally yesterday at the harbor and also got the judgment of the Supreme Court confirming and affirming the decision of the trial court that the Freedom of Information Act is an act for all tiers and for all levels of government and must be upheld by all institutions, either governmental or public, for the purpose of giving Nigerians the requisite information that they requested from any agency or institution of government.
Finally, before we let you go, Barrister, do you think that this particular ruling has set some sort of precedence, for federal laws to be applicable, down to the states and the local government levels? You think there are other federal laws that might follow suit, so that they can be applicable across every tier of government? What do you think?
Yes, although I don't have directly a law in mind, but I know there must exist some other laws which by nature have the semblance of the Freedom of Information Act, and maybe those laws might also have been experiencing frictions in terms of their applicability and in terms of their enforcement, so they can follow suit. Because it's all about transparency, it's all about governance, it's all about catering for the needs of Nigerians. Since Nigeria is a democratic government, then there is no reason why that the laws will not be uniform. For instance, the Freedom of Information Act should be a uniform law from the onset. There shouldn't have been any issue arising from its applicability. It's of no basis and of no moment. So with this judgment now, I think any law or any other enactment of the National Assembly that deserves to be attended to and that Nigerians deserve to benefit from, they can also follow the same procedure as applied in the case of Osaku, in order to see that those laws will now have a national applicability for the purpose of Nigerians to benefit from those laws.
Barrister Mohammed Usman, thank you so much for your time and your insights in this subject matter. We appreciate you.
Well, thank you so much for having me too. Thank you.
All right, New Day continues right after this timeout. Stay with us.
Signature TV, news in your pocket.